So what was John Roberts thinking when he stole some of your liberty? Oh, Mr. Call Screener, let's see this guy. Roberts helped us because he's keeping the issue alive against Obama. Oh, genius. I'll make sure he's on hold. There was an interview done with John Roberts in The Atlantic, a liberal site and magazine, by Jeffrey Rosen, who is really a lightweight but manages to bounce around here and there. And I found this on a great website, freerepublic.com. And I'm going to read you a few parts of this just so you know what we're talking about, and we will link to it on marklevinshow.com as well as my social sites. And you'll see from what I read to you, Roberts rejects constitutional consistency. That is, the consistent application of originalist interpretation. It's a shocking article. He fancies himself John Marshall. I promise you he's no John Marshall. And even John Marshall isn't the John Marshall so many lawyers claim him to be. But that's another story. So this Rosen says in February 2007, he went to the Supreme Court to interview Roberts, who just completed his first term. The conversation turned to judicial disappointments. It's sobering to think of the 17 Chief Justices. Certainly a solid majority of them have to be characterized as failures, Roberts said with a rueful smile. The successful ones are hard to number. He went on. Matter of fact, for printed pages, he went on a lot. 9 pages. Some of the least successful Chief Justices, Roberts suggested, had faltered because they misunderstood the job, approaching it as law professors rather than as leaders of a collegial court. In Roberts' view, the most successful Chief Justices helped their colleagues speak with one voice. Unanimous, or nearly unanimous, decisions are hard to overturn and contribute to the stability of the law and the continuity of the court. By contrast, closely divided 5-4 decisions make it harder for the public to respect the court as an impartial institution that transcends partisan politics. How ironic. Nobody has made the court more political or exposed it as more political than John Roberts himself. Roberts suggested the temperament of a Chief Justice can be as important as judicial philosophy. You hear that? In determining his success or failure. And based on the impression he made in his first year on the court and throughout his career, Roberts seems to have many of the personal gifts and talents of the most successful, politically savvy Chief Justices. You see, Rosen's a lib, and he's carrying favor with him. And a month or so ago, he wrote another piece, basically warning Roberts. You know, you said these 5-4 decisions are a problem. Of course, what they meant is if the good guys went on the court. And by good guys, I mean the constitutionalists. Roberts said if the court in John Marshall's era had issued decisions in important cases the way this court has over the past 30 years, we would not have a Supreme Court today of the sort that we have. Oh, you mean like your 5-4 majority decision? That suggests that what the court's been doing over the past 30 years has been eroding to some extent the capital that Marshall built up. Roberts added, I think the court is also ripe for a similar refocus on functioning as an institution, because if it doesn't, it's going to lose its credibility and legitimacy as an institution. Well, you just did, thanks to you. Roberts declared he would make it his priority, as Marshall did, to discourage his colleagues from issuing separate opinions. In Roberts' view, Marshall's success in unifying the court was a reflection of his temperament. He said, Marshall gave everyone the benefit of the doubt. He approached everyone as a friend. The assumption was, this is someone I'm going to like unless proven otherwise. So it's now about like. We're friends. That Ruth Bader Ginsburg, I've never met anybody who's so nice. A radical nutjob, former ACLU general counsel, and if you read her concurring opinion, there is no Constitution. But that said, let's just get along. That's the line. Who said that? Rodney King? Whatever. Let's go on. Marshall was convivial. He took great pride in sharing his Madeira with his colleagues. He was not the artificial glad-hander type. It's just in his nature to get along with people. I I think that had to play an important role in his ability to bring the court together, to change the whole way judicial decisions were arrived at. And he goes on and on. Rosen says, I asked Roberts to contrast Marshall's temperament with that of Thomas Jefferson, his arch rival. Roberts said Jefferson certainly did not have the common touch. To some extent may be affected, and perhaps I'm being unfair to Jefferson, but he had more of almost like a philosopher's attachment to the idea. Now, this is a guy, the Chief Justice, for all intents and purposes, trashing Thomas Jefferson, who had more to do with the founding of this country than John Marshall ever did. While it's true that John Marshall fought at the Battle of Trenton, I'm talking about in terms of the Declaration. Even though Jefferson wasn't at the Constitutional Convention, he had his invisible hand involved with Madison and some of the others. I mean, you got to be kidding me. But here's the key. Roberts praised justices who were willing to put the good of the court above their own ideological agendas. Now, this guy Rosen, he doesn't even know what an ideological agenda is, because on the right, we don't have an ideological agenda. We seek to uphold the Constitution. That's not an ideological agenda. That's what you take an oath to do. Roberts said, a justice is not like a law professor who might say, this is my theory, and this is what I'm going to do, be faithful to and consistent with. And in 20 years, we'll look back and say, I had a consistent theory of the First Amendment as applied to a particular area, he explained. Instead of 9 justices moving in 9 separate directions, Roberts said, it would be good to have a commitment on the part of the court to acting as a court rather than being more concerned about the consistency and coherency of an individual judicial record. There you have it. So he doesn't view his job as trying to cobble together 5, 6, or 7 votes to uphold the Constitution under various circumstances. No. It's to cobble together 6 or 7 votes, to cobble together 6 or 7 votes for the good of the court. How about for the good of the country? Roberts said Marshall's example had taught him that personal trust in the Chief Justice's lack of an ideological agenda was very important, and Marshall's ability to win this kind of trust inspired him. So his lack of a belief system, that is, a lack of a belief in the Constitution. I mean, where's the middle ground with a Ruth Bader Ginsburg? Where's the middle ground with a Elena Kagan on these big issues, which really bring to fore the differences? Are you telling me that a justice nominated by Obama, who has a completely different set of standards than one nominated by Ronald Reagan, that it's more important that they agree than the right decision be issued? Well, there you have it, ladies and gentlemen. You've been sitting there scratching your head. How can a conservative justice, that is an originalist like Roberts, so blow this decision? How can he rewrite the Constitution of the United States, rewrite the statute, not only uphold Obamacare, but throw the door wide open to massive government power against the individual? Now you know why. He had to make a decision. Am I going to hold my position with the constitutionalists on the court and then be attacked by the lib media, be attacked in every liberal constitutional class and in every law school in this country virtually, attacked in the editorial pages of the big lib newspapers, be written off as a right-winger, or do I join the other 4? And if I join the other 4, I've got to come up with a different theory. I've got to come up with a different theory. They'll support me no matter what because I'll be upholding Obamacare. But I got to come up with a different theory so conservatives don't view me as a complete lout. But what does it matter, folks? He takes a different provision of the Constitution, rewrites the language in the statute, ignores the limits on taxation in the Constitution that only allow federal income tax under the 16th, and 2 other forms of taxes, generally, excise taxes and direct or capitation taxes that have to be apportioned among the states. Mark, what does that mean? Nobody knows what that means. That's why they never did it. And when it was raised by the dissent, which one of these taxes are you using? He said, hey, don't worry about the labels. Don't worry about the labels. Yes, because now we know the Chief Justice is there to defend the court and to be liked, to be personable. That's more important than anything else. That's what he got out of John Marshall. That's what he got out of Marbury versus Madison. In other words, I hate to say this, he didn't get anything out of it. Absolutely unbelievable. Now, you folks listening to this program for the first time, this is the way I do it. We get into substance, we get into information, we'll get into calls and opinion, but this is how we have to lay the foundation. And there's a little bit more foundation to lay before I move on to callers and so forth.